Okay, stay with me here because I need to take you back before I can take you forward. It's October 20th, 1973, a Saturday night. Richard Nixon has just ordered the firing of Archibald Cox, the special prosecutor investigating Watergate. Attorney General Elliot Richardson refuses. He resigns. Deputy Attorney General William Recolchas refuses. He's fired. Finally, Solicitor General Robert Bork carries out the order. The Saturday Night Massacre, they called it. And here's the thing that everybody forgets about that moment. The institutions held not because they were designed to be unbreakable, but because individual human beings inside those institutions made choices. Richardson chose resignation over complicity. Recolchas chose termination over obedience. The courts kept issuing orders. Congress kept investigating. The machinery of accountability, imperfect and slow and frustrating, kept grinding forward. I'm telling you this because at 3:17 p.m. Eastern Time today, January 10th, 2026, an individual human being inside an American institution made a choice. And that choice may have just changed the trajectory of this republic. Judge Tanya Chutkan, a federal judge in the District of Columbia, did something that has never happened in 249 years of American constitutional history. Never, not during Watergate, not during Iran-Contra, not during Clinton, not during either of the previous Trump impeachments. She formally referred criminal conduct by a former president of the United States directly to Congress and demanded immediate impeachment proceedings. Let me say that again, because I need you to understand the magnitude of what occurred this afternoon. A sitting federal judge looked at the evidence in front of her. 14 documented violations of court orders, witness intimidation, obstruction of justice, and she concluded that the judicial branch had exhausted its options, that Congress, the people's representatives, could no longer wait, that the constitutional order itself was at stake. This isn't speculation. This isn't anonymous sourcing from people familiar with the matter. This is a 47-page legal document filed in federal court, available to the public right now, bearing the signature of a lifetime appointed federal judge. And in approximately 72 hours, the House of Representatives will vote on whether Donald Trump becomes the first president in American history to be impeached 3 times. All right, let me walk you through exactly what happened today, because the details matter. They always matter. Judge Tanya Chutkan presides over one of the federal criminal cases against Donald Trump. You'll remember her. She's been in the news for months, and for months she has been dealing with something no federal judge in American history has ever confronted at this scale: a defendant who simply refuses to follow court orders. Now, here's what you need to understand about how federal courts work. Judges have tools, limited tools, but tools nonetheless. When a defendant violates a court order, the judge can issue warnings. The judge can impose fines. The judge can hold the defendant in contempt. In extreme cases, the judge can revoke bail. But what happens, and this is the question that constitutional scholars have debated for 2 centuries, what happens when none of that works? What happens when a defendant is wealthy enough that fines are meaningless? When a defendant is powerful enough that incarceration seems politically impossible? When a defendant is defiant enough that warnings are treated as suggestions? That's the trap Judge Chutkan has been caught in for months. Gag orders violated, witnesses contacted despite explicit court prohibitions, social media attacks on prosecutors, judges, potential jurors. Not once, not twice. 14 documented times in 3 months. 14. Each time the court issued warnings. Each time the court imposed contempt citations. Each time fines were levied. And each time the behavior continued. Today, Judge Chutkan stopped asking. She filed what's called a formal criminal referral. And I want you to think of this very specifically. Think of it as a federal judge officially telling Congress, I have exhausted every tool available to me. This defendant is so dangerous to the administration of justice that you, the legislative branch, need to act. Now, immediately, today. The language in the referral is worth reading directly. And I'm going to read it to you because words matter, especially words written by federal judges in formal legal documents. Quote, "The defendant's repeated violations constitute a clear and present danger to the administration of justice and demand immediate congressional intervention." Clear and present danger. That's not judicial rhetoric. That's not hyperbole. That's a legal conclusion carrying enormous constitutional weight. Those words have specific meaning in American jurisprudence. They invoke the highest possible level of threat. And Judge Chutkan didn't just send a summary to Congress. She sent the entire evidentiary record. Let me tell you what's in that record, because this is where it gets devastating. 14 gag order violations, each one time-stamped, each one screenshotted, each one archived in federal court records. Transcripts from 7 separate contempt hearings where Trump was warned directly, personally, explicitly by the judge herself. Phone records showing coordination with co-defendants despite court-ordered no-contact restrictions. Social media posts targeting prosecutors, judges, and members of the jury pool, the very people who will decide his criminal fate. Internal communications from Trump's own legal team acknowledging violations. Sworn declarations from former federal judges, respected jurists with decades on the bench calling the conduct unprecedented. And then the most damaging piece of evidence in the entire referral, recorded conversations. Audio of Trump discussing plans to defy court orders with close advisors. Stay with me here because this distinction matters enormously. This isn't evidence that just shows behavior. It establishes intent. It's not he posted something he shouldn't have. It's he discussed a plan to violate court orders, and then he executed that plan, and we have him on tape. This is the kind of evidence that ends careers, that ends administrations, that ends political movements. And it was handed to Congress in a single 47-page document at 3:17 this afternoon. Now, I promised you historical context, and here's where it becomes essential. This has never happened before. Not during Watergate, when Nixon was fighting subpoenas all the way to the Supreme Court. Not during the Clinton impeachment, when obstruction was a central allegation. Not during the Saturday Night Massacre, when a president fired everyone who stood in his way. Never in 249 years has a sitting federal judge formally initiated impeachment proceedings against a president or former president. Think about what that means. Think about every constitutional crisis this country has weathered, every scandal, every abuse of power, every moment when we wondered whether the system could hold. In none of those moments did a federal judge conclude that the conduct was so egregious, so dangerous, so fundamentally threatening to the constitutional order that Congress had to be told, act now. Judge Chutkan crossed a line today that no judge has ever crossed. And here's what I think is critical to understanding why. A judge's authority, any judge's authority, depends entirely on enforcement. If orders can be violated without consequence, they become meaningless, not just for one defendant, for every defendant in every courtroom across the entire federal system. If one defendant can ignore the court repeatedly, publicly, defiantly, and face no real consequences, then the message goes out to every defendant in America, follow the rules or don't. It doesn't matter. Judge Chutkan understood that her continued tolerance wasn't just about one case. It was damaging the judiciary itself. Every unpunished violation weakened the entire institution, so she escalated, not because she wanted to, not because she's political, not because she's partisan, because she concluded she had no choice. The criminal referral isn't about politics. It's about institutional survival. It's a federal judge saying, I cannot fix this alone. The conduct is too dangerous. Congress has powers I don't have, use them. This matters, and I really need you to stay with me here because it changes the frame entirely. Trump's defense has always been that this is political persecution, partisan prosecutors, Obama-appointed judges, deep state conspiracies, witch hunts. That defense collapses when the person making the accusation is a lifetime appointed federal judge acting on documented evidence filed under oath. Judge Chutkan didn't leak to reporters. She didn't give interviews on cable news. She didn't tweet. She filed a formal legal document in open court, attached the evidence, and transmitted it through official constitutional channels. That's not persecution. That's procedure. And now Congress has to respond. Within hours of Judge Chutkan's referral, Congress moved faster than anyone expected. And here's the thing. Most people don't know. Articles of impeachment had actually been drafted months ago. They've been sitting quietly in committee since November 2025, 8 specific charges: obstruction of justice, witness tampering, contempt of court, violation of judicial orders, abuse of power, conduct unbecoming a public official, threat to the constitutional order, incitement. Until today, those articles had about 87 co-sponsors, all Democrats, not nearly enough to pass. As of this evening, that number has exploded to 231. That's a majority of the House of Representatives. That's enough votes to impeach immediately, tonight, right now, if they wanted to. And here's what's remarkable. The new names aren't progressive Democrats from safe blue districts in San Francisco and Brooklyn. They're moderate Republicans from swing districts. Republicans who defended Trump through 2 previous impeachments. Republicans who went on television and called the investigations partisan. Republicans who voted against impeachment twice. They're breaking. Representative Mike Lawler of New York held a press conference this morning. He's a Republican from a district Biden carried in 2020. Listen to what he said. Quote, "I swore an oath to the Constitution, not to any individual. When a federal judge says a former president is obstructing justice, I have a duty to take that seriously." Representative Don Bacon of Nebraska, another Republican, another defection. The political calculus has shifted overnight, and Democratic leadership isn't waiting. They've invoked something called Rule 99, Section 2. It's a fast-track procedure that mandates a full House vote within 72 hours. That motion was filed this morning, which means by Monday, January 13th at the latest, the House of Representatives will vote on whether to impeach Donald Trump for the 3rd time, 72 hours. That's the window. With 231 co-sponsors already committed, the math is unforgiving. Impeachment is no longer a question of if. It's a question of margin. Will it be narrow, 218 to 217, or will it become a landslide as more Republicans break ranks over the weekend? Because that list is growing by the hour. Moderate Republicans who were waiting for political cover are abandoning ship. They see a federal judge's criminal referral. They see documented evidence of obstruction. They see witnesses intimidated, jury pools contaminated, court orders treated as suggestions. They hear from constituents exhausted by constant chaos. And they understand finally that they cannot go on national television and defend witness tampering, not when a respected federal judge has signed her name to a 47-page referral, not when the evidence is public, not when the recordings exist. The political ground has shifted beneath the Republican Party in a single afternoon. And Trump's response, I need to tell you about Trump's response because it made everything worse. Since yesterday afternoon, he has been posting constantly on Truth Social, all caps tirades about rigged courts, attacks on what he calls Obama judges, claims of political persecution, conspiracy theories about the deep state. But then came one post that set off alarm bells across Washington. Quote, "If Congress moves forward with this witch hunt, patriots must converge on Washington. The Second Amendment exists for moments like this." Read that again. A former president of the United States openly calling for armed resistance to Congress. That is not campaign rhetoric. That is not political posturing. That is not metaphor or hyperbole or whatever his defenders will claim tomorrow morning. Law enforcement is treating it as a threat, a credible threat, an imminent threat. And here's what you need to understand about the legal dynamics at play. Every post he makes now becomes evidence. Every escalation strengthens the case against him. He is making the prosecution's argument for them in real time on his own social media platform. Washington has responded accordingly. National Guard units are deployed across the Capitol complex. Steel barricades are rising around federal buildings. Armed security is visible at every entrance, every exit, every checkpoint. Pro-Trump demonstrators are gathering near the National Mall. Counter-protesters demanding accountability are assembling near the Supreme Court. Law enforcement is everywhere: helicopters, armored vehicles, sharpshooters on rooftops. This is what the Capitol of the United States looks like right now. Not because of an election, not because of a foreign threat, not because of a terrorist attack, because a former president is facing impeachment and has called for armed resistance. Now, most of the coverage right now is focused on the impeachment vote. Will it pass? How many Republicans will defect? What happens in the Senate? Those are important questions, but they're not the most important questions. Here's what most people are missing. Judge Chutkan's referral didn't just go to Congress. The evidence of witness tampering, obstruction of justice, and criminal contempt has also been forwarded to the Department of Justice. That means this isn't just a political process anymore. It's a parallel criminal investigation. And I need you to understand what that means practically. If federal prosecutors establish that Trump directly coordinated with witnesses to influence testimony, that's subornation of perjury. That's a serious federal offense. Witness tampering carries significant prison exposure. So does obstruction of justice. Multiple federal grand juries are already active. Washington, D.C., Miami, Atlanta. It is entirely plausible, I would say likely, that new criminal indictments arrive while Senate impeachment proceedings are still underway. Think about that for a moment. We could be watching a Senate trial while a federal grand jury simultaneously hands down new charges. The legislative branch and the judicial branch operating on parallel tracks. Multiple accountability mechanisms moving at once. This is constitutional territory. The framers anticipated but hoped would never be tested. And then there's something else, something barely being discussed publicly. Reports indicate that quiet conversations about the 25th Amendment have already begun. Now, the 25th Amendment allows for removal without impeachment if a president is deemed unable to discharge the duties of office. It requires the vice president and a majority of the cabinet. It can move quickly, overnight, if necessary. The fact that this option is even being discussed tells you how severe officials believe the situation has become. Let me be clear. I'm not predicting that the 25th Amendment will be invoked. I'm telling you that it's being discussed, and that discussion itself is historically significant. Meanwhile, the Republican Party is fracturing in real time. You have the Loyalists representatives like Marjorie Taylor Greene and Matt Gaetz doubling down, calling for protests, defending Trump without reservation, attacking any Republican who breaks ranks, using words like traitor and Reno, and worse. And you have the pragmatists like Lawler and Bacon breaking away, citing their oaths to the Constitution, looking at the evidence, doing the math on 2026. Internal threats are escalating. Lawmakers who defected are facing harassment. Their staff are being threatened. Their families are being targeted on social media. The party itself is tearing apart in public. With the 2026 midterms just 10 months away, many Republicans see electoral catastrophe ahead if they remain tied to this level of chaos. They're calculating, they're hedging, they're preparing exit strategies. And here's the deeper reality. Once members publicly defect, the dam doesn't reseal, it breaks. Every new defection makes the next one easier. Every Republican who steps forward and says enough gives cover to the next Republican waiting in the wings. That's how political coalitions collapse, not gradually. Suddenly, all at once. What we're watching right now isn't just about one impeachment vote. It's about the potential collapse of a political coalition that has dominated Republican politics for nearly a decade. And internationally, the consequences are already visible. A former American president threatening armed resistance while facing impeachment is not a normal headline. This is not something our allies have seen before. This is not something our adversaries expected to see. Our allies are alarmed. They're calling the State Department. They're having emergency meetings. They're wondering whether the United States can be relied upon. Our adversaries are watching closely, assessing instability, probing for weakness, looking for opportunities. Domestic turmoil always carries global consequences, always, every time, without exception. And right now, to the rest of the world, the United States looks deeply, profoundly unstable. Let me talk about what this means for ordinary people. Not politicians, not lawyers, not pundits, regular Americans trying to understand what's happening to their country. First, the economy. Markets hate uncertainty, and there is nothing more uncertain than a constitutional crisis unfolding in real time. Futures markets are already reacting. International investors are watching when the world's largest economy looks politically unstable, money moves, interest rates can shift, supply chains can tighten, hiring decisions get delayed. None of this is guaranteed, but all of it becomes more likely when the political system is consumed by crisis. Second, trust. This is harder to measure, but maybe more important. How do you explain to your children what's happening right now? A former president calling for armed resistance, National Guard troops surrounding the Capitol, a federal judge concluding that obstruction of justice has become so severe that Congress must act immediately. This is the kind of damage that's hard to rebuild. Faith in institutions, belief that the system works, trust that disagreements can be resolved through process rather than force. Every generation of Americans has to decide whether the Constitution is just words on paper or something that actually constrains power. This is one of those moments right now, this week. Third, safety. Law enforcement isn't deploying the National Guard as a precaution. They're deploying it because they believe the threat is real. The memory of January 6th isn't abstract. It's operational. Agencies know exactly what happens when rhetoric turns to action. They watched a mob attack the Capitol in real time. They watched officers beaten with flagpoles. They watched windows shattered and chambers breached. They are determined not to be caught off guard again. For people in Washington right now, federal employees, Capitol staff, families living near government buildings, the next 72 hours will be tense. Security checkpoints, street closures, helicopter noise through the night. That's the human reality of constitutional crisis. It's not just cable news drama, it's people canceling plans, keeping children home from school, wondering whether their commute will be safe. Fourth, the future. Whatever happens Monday, the political landscape has permanently changed. If Trump is impeached for the third time, he becomes a historical figure unlike any other, defined not by policy accomplishments, but by repeated accountability proceedings. 3 impeachments, multiple criminal indictments, a federal judge formally declaring him a danger to justice. If he's somehow acquitted in the Senate, he remains politically viable but legally exposed, with federal criminal cases continuing regardless of congressional votes. Either way, the next few years will be consumed by trials, appeals, investigations, and ongoing instability. There's no path back to normal from here. Only forward through whatever comes next. All right, let me lay out what the next few weeks could look like. Not as predictions. I want to be careful about that, but as genuine possibilities based on what we know right now. Scenario 1, impeachment passes, Senate convicts. This requires all Democrats, plus at least 18 Republicans in the Senate. That's a high bar, but it's not impossible, especially if more evidence emerges during a Senate trial or if Trump continues escalating his rhetoric in ways that make him impossible to defend. If conviction happens, Trump would be permanently barred from holding federal office again. His political career would be constitutionally over. Scenario 2, impeachment passes, Senate acquits. This is perhaps the most likely outcome based on historical patterns. The House impeaches, the Senate holds a trial, but 67 votes for conviction don't materialize. In this scenario, Trump survives legally, but is severely weakened politically. The evidence presented during trial becomes permanent public record. Republican senators who voted to acquit face that vote in every future campaign. Scenario 3, the 25th Amendment is invoked. This would be faster than a Senate trial, potentially overnight. It requires Vice President Vance and a majority of the cabinet to conclude that Trump is unfit. It's being discussed. Whether it actually happens depends on factors we can't see from the outside. But the mere fact that it's on the table shows how unstable the situation is perceived to be by people inside the government. Scenario 4, additional criminal indictments. Independent of Congress, federal prosecutors continue their work. New charges could arrive at any time: witness tampering, obstruction, criminal contempt. This would create the unprecedented situation of a former president facing active criminal prosecution while simultaneously undergoing congressional impeachment proceedings, 2 tracks operating simultaneously, neither waiting for the other. And here's what's critical: none of these scenarios are mutually exclusive. Several could happen simultaneously. And that's perhaps the most important point. Trump is not facing one threat. He's facing multiple threats converging at once: congressional, judicial, criminal, political. The next 72 hours will determine which of these paths becomes reality. So where does that leave us? Here's what you need to remember from everything we've covered tonight. 1. A federal judge has formally referred criminal conduct to Congress for the first time in American history. This is not politics. This is not partisanship. This is a lifetime appointed federal judge acting on documented evidence of obstruction and witness tampering. 2, the House will vote on impeachment by Monday. With 231 co-sponsors already committed, passage is virtually certain. The question now is margin and whether more Republicans break ranks over the weekend. 3, this is bigger than impeachment. Criminal investigations continue. The 25th Amendment is being discussed. The Republican Party is fracturing in real time, and the next 72 hours will shape presidential accountability for generations. I've been covering American politics for a long time. I've seen crises, I've seen scandals. I've seen moments that felt like they might break the system. This feels different. Not because the outcome is certain. It isn't. Not because the good guys win in the end. I don't know if they do. But because the machinery of accountability, the slow grinding gears that the founders built into this system, are actually moving. A judge saw conduct she could not tolerate and she acted. Members of Congress are seeing evidence they cannot ignore and they're responding. The Constitution, that 237-year-old document, is being tested in real time, and we're going to find out whether it holds. Stay with us.